Nobody expected the agents to talk. That was the assumption that had held for months. The assumption that the people who understood exactly what was happening inside the Bureau would absorb the pressure, document their concerns internally, and wait for circumstances to change rather than step into a federal courtroom and put what they had witnessed on the permanent public record. That was the calculation. That was the assumption baked into every layer of the political strategy surrounding Kash Patel's tenure at the Federal Bureau of Investigation. The agents would stay quiet. They would follow orders. They would do what career federal law enforcement officials have always done when political pressure arrived from above: absorb it, adapt to it, and keep their heads down until it passed. That calculation turned out to be wrong. It turned out to be wrong in the most direct and consequential way. A political calculation can fail not because of a leak, not because of a journalist, not because of an opposition research operation running in the background, but because the people inside the institution decided that what they had witnessed required them to say something. In the right place, in the right forum, under the right legal obligation. Because on the morning that federal court proceedings opened in Washington, it wasn't outside critics or political opponents or anonymous sources speaking to journalists who put the first damaging account of Kash Patel's conduct on the record. It was FBI agents. Active credentialed career federal law enforcement professionals who had spent years inside the institution. Patel now lead people who understood, better than almost anyone outside the building, exactly what had been happening inside it, and they had decided to talk, not to reporters, not to congressional investigators, not to the political opposition looking for ammunition ahead of the next election cycle, to a federal judge. Under oath, in open court, on the record. The proceedings had been scheduled for weeks. On paper, in the formal legal filings, in the official descriptions of what the court was being asked to consider, they concerned a specific set of institutional decisions made inside the FBI in the months following Patel's confirmation, decisions about personnel, about investigative priorities, about the handling of specific cases that had been running before he arrived. What they became was something larger than that, because when the first agent took the stand and began to testify, what came out wasn't the kind of carefully managed institutional language that federal officials typically deploy in legal proceedings. It wasn't hedged. It wasn't qualified. It wasn't constructed to protect the speaker from consequences. While technically placing something on the record, it was specific: dates, names, directives given, responses received, decisions made at the senior level of the FBI that the agent had personally witnessed and was now describing, in precise operational detail, to a federal judge in an open courtroom. The gallery was full. This was not a closed proceeding. This was not a classified hearing conducted behind the sealed doors of a Senate committee room where the public would only ever hear a summary of what was said. This was an open federal courtroom in Washington, with public seating, a live record being transcribed in real time, and every word spoken from the witness stand becoming part of the permanent judicial record of the United States. Reporters, who had been covering the FBI beat for years, sat in the first rows, their notebooks open, their pens moving faster than they had in months. Legal observers, congressional staffers, former bureau officials who had come to watch something they had not expected to see in their professional lifetime's career. FBI agents testifying in federal court about the conduct of their own director. The first agent testified for 40 minutes. He did not appear nervous. He did not hedge or equivocate or reach for the kind of carefully managed language that officials use when they want to put something on the record, without fully committing to what it means. He spoke the way someone speaks when they have decided, after a long time of deciding, that the truth is more important than the consequences of saying it. What he described was a pattern, not a single incident, not an isolated decision that could be explained away as the kind of judgment call that any executive makes in a large institution, under pressure. A pattern of directives that came from the director's office and that conflicted, in specific and documentable ways, with the legal obligations of the Bureau and the professional standards that career agents are required to follow. He was asked if he had raised these concerns internally. He said he had. He was asked what happened. When he did, he described what happened. The courtroom went quiet in a way that courtrooms rarely go quiet. Not the procedural silence of a proceeding running its course, but the specific, weighted silence that fills a room when testimony lands with enough specificity and credibility that everyone present understands they are hearing something that cannot be walked back. Second agent took the stand after a short recess. Testimony covered different events, different dates, different specific decisions, but the pattern it described was consistent with what the first agent had said. Consistent in structure, in the kind of institutional pressure being applied, and in the gap between what was being directed from above and what the law and professional standards required. She testified for 55 minutes at several points during her testimony. The attorney representing the government's position objected to the line of questioning. The judge overruled each objection. When she finished, the attorney for the government requested an adjournment. The judge denied it. To understand why this moment carries the institutional weight that it does, you need to understand what it means for FBI agents to testify against their own director in federal court. The Federal Bureau of Investigation is not a normal federal agency. It occupies a unique position in the American institutional architecture, a domestic law enforcement and intelligence body whose independence from political direction is not merely a tradition but a structural requirement. The FBI investigates public corruption. It investigates violations of federal law by public officials. It is, by the nature of its mandate, an institution that powerful people have strong incentives to control. The protections, built around its independence, exist precisely because of that pressure. The FBI director serves a 10-year term, specifically to insulate the position from short-term political pressures. The length of that term means that a director will outlast the administration that appointed them. That structural feature is not accidental. It is a deliberate design choice made by Congress to ensure that whoever leads the Bureau answers primarily to the law, not to the political figure who put them in the job. When career agents testify in federal court that those protections have been violated, that directives have come from the director's office that cross the line between legitimate executive authority and improper political interference in law enforcement, they are not making a political argument. They are making a legal one. Under oath, with the full weight of federal perjury statutes behind every word they say. That is a different category of accusation from anything that appears in a news article or a congressional hearing. A news article can be disputed. A congressional hearing can be a leak can be dismissed as the product of disgruntled employees with political axes to grind. Federal court testimony, given under oath, in open proceedings, by credentialed career law enforcement officials who have spent their careers building exactly the kind of evidentiary records that courts rely on. Testimony entered into the permanent record of the United States judicial system that is not so easily dismissed. It does not disappear when the news cycle moves on. It does not soften when political allies issue supportive statements. It does not become less credible because the institution being examined has interests in characterizing it a different way. It sits in the record, exactly as it was given, for as long as the record exists, and it gets harder to dismiss with every agent who takes the stand. The third agent testified in the afternoon session. He had been with the Bureau for 19 years. He had worked public corruption. He had, by his own account, spent nearly 2 decades doing exactly the kind of work the FBI exists to do, building cases, following evidence, operating within the legal and institutional framework that separates the Bureau from the political apparatus it occasionally needs to investigate. His testimony was the most detailed of the three. He had brought documents with him, not documents he had assembled in anticipation of litigation. Documents he had created at the time the events he was describing were occurring, notes, records, internal communications that he had preserved because, as he explained to the court, he had understood at the time that he might one day need to account for what he had witnessed. He described specific communications, specific meetings, specific moments in which the pressure from the director's office had intersected with active investigations in ways that he had documented contemporaneously, meaning he had written things down at the time, not reconstructed them afterward, and those contemporaneous records were now in the possession of the court. He was asked if he believed what he had witnessed constituted obstruction of justice. He said that was for the court to determine. He was asked if what he had witnessed was consistent with the proper exercise of executive authority within the Bureau. He said it was. The proceedings are ongoing. The full picture of what has been alleged and what evidence supports those allegations will take time to develop through the formal processes of federal litigation. But what has already been placed on the record is not going away. 3 career FBI agents, not political operatives, not anonymous sources, not critics speaking from outside the institution, have testified under oath in federal court about the conduct of the director of the Federal Bureau of Investigation. They described a pattern. They described specific incidents. They described the gap between what they were directed to do and what the law required. They described what happened when they raised those concerns through the institutional channels that are supposed to exist precisely for that purpose. The White House response came quickly. That, too, was not surprising. Political responses to institutional accountability proceedings follow a predictable architecture. The players change. The institution under scrutiny changes, but the structure of the response rarely does. The White House issued a statement in the early afternoon. It described the proceedings as politically motivated. It questioned the credibility of the agents involved. It suggested that the testimony reflected the institutional resistance of career bureaucrats opposed to the reforms Patel had been appointed to implement. These are familiar responses. They are the standard architecture of a political defense mounted against institutional accountability, but they run into a problem that political defenses always run into when the accountability is happening in federal court rather than in the court of public opinion. Agents are not speaking to public opinion. They are speaking to a federal judge who has the authority to weigh evidence, assess credibility, and reach legal conclusions that carry binding force regardless of what the political environment surrounding the case looks like under oath with their contemporaneous records submitted as exhibits, and the judge is not reading the White House statement. The judge is reading the testimony. That distinction matters more than anything else that has been said about this proceeding in the hours since it began, because political defenses are built for political arenas, for the news cycle, for the social media conversation, for the audience that forms its views based on who makes the more compelling argument in the available time. Federal court is not a political arena. It is a place where documents are submitted, where testimony is given under penalty of perjury, where the record is built from evidence rather than argument, and where the institution of the judiciary, independent of the executive branch that appointed the official now being examined, applies the law to the facts as they are established by that evidence. 3 agents walked into that courtroom. They sat in the witness chair. They raised their right hands. They swore to tell the truth, and they told a federal judge, not a political ally, not a friendly journalist, not a congressional committee operating along partisan lines, exactly what they had seen inside the institution they had devoted their careers to. All of it. On the record. In open court, the record is open, the testimony is in, and whatever the political response produces, it cannot reach inside a federal courtroom and change what 3 career FBI agents said under oath about the man who leads their bureau. That is the part that doesn't go away. Not the White House statement, not the political framing, not the counter-narrative assembled by the communications operation surrounding the director. The testimony given under oath by agents who knew exactly what they were doing when they walked through that courtroom door. So what do you think about what just happened in that courtroom? When career FBI agents step forward and testify under oath, does that change how you see the situation? Or do you think there's still more to the story that we're not hearing yet? Drop your thoughts in the comments. I read every single one. And if you want more real breakdowns of the most intense moments in Washington, make sure to like the video and subscribe to Capital Clash so you don't miss what comes next.